Hello, this is case 3, safety glove discharge with just cause. Next slide. The parties involved in this case are Rafael Gomez, General Manager, Aaron McNamara, the employee discharged for safety violations, Local 37, the United Paper Workers International Union, and I am Kimberly with the Labor Relations Representative. Next slide. The purpose of this presentation is to give you the background on Ms. McNamara and what led up to her termination, the reasons why Barrera Recycling has strict policies for the safety of our employees, what the definition of just cause is, and why we feel we had just cause to terminate Ms. McNamara, and what the company plans to do in the future. Next slide. Ms. McNamara has been with the company for over 20 years and recently located to Long Beach location. Her duties include removing the plastic straps from the paper bundles and placing them in the baling machine. On occasion, she will sort loose paper, tin cans, and glass bottles. Bud 2018-337. By October, Mr. Gomez had had 6 conversations with Ms. McNamara regarding her work performance and safety violations. On October 26th, 7th conversation took place, and Ms. McNamara was reading a Sports Illustrated during work hours. On October 28th, Mr. Gomez felt it was warranted to suspend Ms. McNamara for violating the Barrera rules and regulations, and she was informed that if she violated them again within the next 12 months, she would be terminated. Bud 2018, page 337-338. By December 9th, Ms. McNamara was seen by Mr. Gomez sorting items without her safety gloves again. He approached her and asked her where her gloves were. She said they were in the truck, so she went to get them. About 30 minutes later, Mr. Gomez felt it was warranted to terminate Ms. McNamara for the violation. Bud 2018-338. Next slide. Workplace safety is a top priority for our company. We institute our safety policies in accordance with OSHA, the Occupational Safety and Health Standards. Standard number 1910.138A through B of the OSHA regulations 1994. Employers shall select and require employees to use appropriate hand protection when employees are handling hazardous material, anything that can hurt their hands, glass, broken, punctures, abrasions, chemical burns, thermal burns, or extreme heat. Employers need to base their selection of the hand protection on the tasks at hand and what the employees are going to do. 1910. These hazards are here for the safety and protection of our employees. Local 37 also identified that possible discrimination against Ms. McNamara. The EEOC Title 7, number 16, it states that employees must be able to establish, one, that they are part of the discriminatory group protected by the Title 7, and that the alleged harassment and discrimination did occur. Crumpacker and Crumpacker 2007, paragraph 7. By our notes and speaking with Mr. Gomez, there was no discrimination involved. Everything had to do with her lack of following safety policies. Also stated was Article 20 of our contract clearly states causes for immediate discharge, and Ms. McNamara clearly violated number 7, number 10, and number 12. Bud 2018-338. Next slide. We have received notice from Local 37 has filed a grievance on behalf of Ms. McNamara stating that she was unjustly discharged. Bud 2018, page 338. According to the implied contract exception of the employment at will doctrine, which states that any company with a contract, employees will be disciplined or terminated only for just cause or under specified circumstances or provisions which indicate that an employer will follow specific procedures before disciplining or terminating an employee. Mull 2001, page 8. By all record, Mr. Gomez followed all these provisions and documentation is present for proof. Because California is among the 10 states where just cause firing legislation was introduced to the state legislature, Kruger 1991 paragraph 32, we could not have terminated Ms. McNamara without having verifiable just cause. Therefore, the union does not have the means to prove that Ms. McNamara's termination was unjust. Next slide. According to Bud 2018, just cause means that there must be a valid supportable reason for being disciplined or fired. Page 327. Therefore, in order to determine whether Mr. Gomez had just cause to terminate Ms. McNamara, we reviewed the 7 tests of just cause, Bud 2018, page 328. Next slide. Proof that we had just cause to terminate Ms. McNamara is simply by answering the 7 tests of just cause. Was she given advance warning of the consequences of her conduct? Yes, she had several verbal reprimands, 3 days suspension, and a written warning that laid out what would happen if she broke any more policies within the next 12 months. Was the rule, order, or standard reasonably related to the orderly, efficient, and safe operation of the employer's business? Yes, she consistently did not wear her safety gloves while handling the broken glass and tin cans. She slept during safety meetings and read non-work related magazines while on duty. Was the alleged violation thoroughly investigated before discipline? Yes, Mr. Gomez questioned her and reviewed procedures with her on numerous occasions. Was the investigation fair and objective? Yes, it will believe no incident was made up and there were witnesses. Did the investigation reveal convincing proof of guilt? Yes, on each violation, Ms. McNamara did not deny or argue her guilt. Was the employer's discipline non-discriminatory? Yes, it does not appear that Mr. Gomez in any way was discriminating against Ms. Gomez, or Ms. McNamara. He was concerned for her safety. Was the discipline reasonably related to the worker's record and severity of her conduct? Yes, Ms. McNamara had an extensive record of violations, and not wearing her safety gloves could have caused severe injury to her hands. Next slide. As a labor relations representative for this company, I truly believe that there has been sufficient proof that Mr. Goldman had just cause to let Ms. McNamara go. As a precaution for future situations, we are going to be sure to provide additional postings in English and Spanish of the rules and regulations at the entryway of the building, as well as adding English posting to the lunchroom. I believe Mr. Gomez did a fine job documenting each reprimand for Ms. McNamara. However, we are going to continue to implement the system of progressive discipline as outlined below by Mueller 2009, Chapter 9. Verbal warnings, coaching and counseling, retraining if needed, written warnings, suspension, and finally termination. Next slide. In conclusion, it is very evident that Ms. McNamara violated not one but several of the company policies. She never denied not doing any of the violations and did not even argue her suspension. It was not until she was terminated that she decided to go to the union and fight for her job. If Ms. McNamara felt so strongly about wanting to retain her position here, I believe she should have listened to Mr. Gomez in the beginning prior to her termination. Thank you for your time.